Hi, everyone. I am going to try to walk through very quickly the legal framework and the analytic steps that you need to go through when confronted on your campus with a student in crisis who you believe may be at risk of suicide. I'm a disability rights lawyer, and I know a lot of people may not initially think about suicide or self-harm in terms of disability, but the vast majority of people who do engage in self-injurious behaviors have some kind of a mental illness. And as a lawyer, kind of the approach that I bring as a lawyer for people with psychiatric disabilities is to view my job as helping people with mental illness to live lives of their own design. And this stems from a rights-based perspective that I bring as a civil rights lawyer, but also as a mental health advocate. It really comes from a recognition that individual autonomy is therapeutic and really an integral part of people's recovery processes. At the Bazelon Center, a lot of our work is on reforming public systems as well as private and public actors like employers and schools of all types from elementary to post-secondary institutions to help them realize their non-discrimination obligations toward people with disabilities. So that brings us to this first slide that we're already on. And discussing what these obligations are and where they come from. You've probably all heard of Section 504 of the Rehab Act and of the Americans with Disabilities Act. The ADA was amended a few years ago in 2008. Titles 2 and 3 are applicable to you, Titles 2 for state colleges and 3 to private colleges. And then, of course, Section 504 applies to all of you. And then I also wanted to flag the Fair Housing Act that you just need to be aware of its anti-discrimination provisions because it applies to university housing, which some people don't realize. So housing has to be accessible. Universities have to grant reasonable accommodations to their housing policies for people with disabilities, including people with psychiatric disabilities. And they must review their policies or practices to ensure that they don't discriminate against people with disabilities. And hopefully we can talk more about accommodations later on. We also have the regulations implementing those new statutes. We have judicial opinions when judges are interpreting those statutes and they're implementing regulations with respect to a particular situation that arises when in your cases, a student would litigate after having an adverse action taken against them. And then we also have some guidance from the United States Department of Education's Office on Civil Rights where students don't wish to litigate, but they can file a complaint. The OCR will investigate, and some of you might have experience with this or some knowledge of it. And so that's the resolution letters that arise as a result of those investigations can also offer guidance and is another source we can look to in this area. So moving on, this is really a nutshell of everything I'm going to say. Disability law is a bit different than other areas of civil rights law and anti-discrimination law in that in addition to refraining from overtly discriminating against people with disabilities, you also have affirmative obligations to provide reasonable accommodations. And basically, I know that a lot of disability support services offices on campus will have kind of a checklist of accommodations. I always kind of advise people to just crumble that up and throw it away because the sky's kind of the limit with accommodations. And I know, too, that a lot of disability support services offices aren't necessarily primed to think about accommodations for psychiatric disabilities. And in fact, some have policies that are entitled something like accommodations for physical and learning disabilities. So that's just something to keep in mind. Anything is a reasonable accommodation that helps mitigate the impact of someone's disability unless it constitutes an undue burden or a fundamental alteration. An undue burden generally has to do with cost, and the fundamental alteration will often have to do with if someone requested an accommodation that would sort of alter say the course requirements for a particular major or something like that. So, so that's a bit on reasonable accommodations. There's an exception for, you don't have to accommodate someone who, as a result of their disability, poses a direct threat to self or others, and that's defined as a significant risk of substantial harm. I know that there is some buzz around the regulatory changes in Title II of the ADA, so I just want to acknowledge that for purposes of this conversation, given that there is a bit of a lack of guidance in this area, I am assuming that at least at a minimum, you must consider the same 4 factors in situations where a student's disability presents a significant risk of substantial self-harm, that you would have to consider at least at a minimum the same 4 factors that you would need to consider for people whose disabilities might lead to a risk of harm to others. And we'll get to those 4 factors in a minute, but I do just want to say, and I can't emphasize enough, that it is the extremely rare situation when this exception will apply, that someone will pose a significant risk of substantial self-harm that cannot be responsibly addressed by providing the student with reasonable accommodations.